So just looking at the succession law implications. So here we have Peter passing away. And the question being asked is from a Malaysia domicile perspective, dependent claims against the estate in Malaysia, basis of those, dependent claims against property in Hong Kong. So we're looking at this from the clawback claims against trusts in Singapore and Hong Kong. So we're looking at it in the context that if it were found that Peter at his death was Malaysian domiciled, so in this case, he would clearly be a Malaysian domicile of choice, unless he had an origin, oddly enough. Would there be a dependent claim, could there be a dependent claim against the estate in Malaysia? And then with respect to extraterritorial claims, dependent claim against Hong Kong sort of property, and then clawback claims against the trusts in Singapore and Hong Kong. Is it capable of, are we capable of having clawback claims within the context of the Family Provisions Act in Malaysia?
Yeah, the answer to one is yes, as discussed earlier. So yes, a dependent can make a claim against the estate in Malaysia. Now that Peter is been shown to be domiciled in Malaysia, so the courts will have jurisdiction, and the courts can order maintenance against the estate for either the spouse or the child that's not been provided for. The second point, again, you have problems with extraterritorial.
Yeah.
So I think that, you know, that is really a no-go.
Yeah.
I would imagine.
So that particular one, Kim, it seems that when Commonwealth jurisdictions have all been running this piece of legislation, these family inheritance dependent claims, and what there seems to be a sort of common view that they won't exercise discretion where it's land. They don't mind exercising discretion where it's movable assets. But insofar as land is concerned, they say that that's a situs issue and not covered by their discretion. And this is, there's a bunch of authority on this from New Zealand and Australia, where there's a reluctance to exercise the family provision sort of extraterritorially when it's dealing with real property, immovable property. I think probably if, you know, sort of Malaysian courts would probably defer to Commonwealth's judgments on these and see what the other courts are doing, they may well take the view that it's Hong Kong land and therefore it's off limits for us to exercise a discretion on a situs asset. I mean, what do you think about that?
Yeah, I think you're quite right, because the decisions in other Commonwealth courts will be taken into account, persuasive to a Malaysian court, especially when there are no Malaysian court decisions on the same point. Right. So yeah, those decisions would be persuasive to a Malaysian court in terms of how they make the decision.
And in terms of clawback, am I right in my analysis of the Malaysian family inheritance legislation is it doesn't have a concept of clawback? Is that correct?
Yeah, it doesn't have the same provision as set out in the Law Reform Marriage and Divorce Act, which basically gives the right for, you know, either an injunction or a clawback, as you say, in regard to disposition.
Right. Okay, and then looking at it from a Hong Kong perspective, I can run through this fairly quickly. Hong Kong operates in the same way in terms of entitlement, where the Hong Kong court will have discretion where the deceased died domiciled in Hong Kong, but they also have this extrapolation where they're ordinarily resident at any point in the 3 years prior to death. That would also give the Hong Kong court rights to exercise their discretion. So a dependent claim would be possible if Peter had died within 3 years of having been Hong Kong ordinarily resident. Dependent claim against Malaysian property, you would have a clear conflict here because Malaysia would be operating on domicile basis, whereas Hong Kong in this case could be operating on a deemed basis because of the ordinary residence. And in any event, even if the Hong Kong court wanted to do it, I think it would probably not try and move against Malaysian land. If it were going to try it, it would be against Malaysian movables. But given that the Malaysian court has authority through the domicile, it's very unlikely a Hong Kong court would go against, would effectively make an order where it had no chance of being enforced. And in clawbacks, yes, you do have the right within the Hong Kong setting to clawback if there was within 6 years there was a disposition that was seeking to defeat any of these dependent claims. I think that would be possible against the Hong Kong Trust, but not against the Singapore Trust, because the Singapore firewall protections would probably apply